Hello colleagues, I am David Kotamasi, Assistant Professor at the Department of Environmental Studies, University of Delhi, and today I will be talking to you about the relationship between environment and human rights, the right to life and liberty, equality before law, freedom of expression, and the right to be free from discrimination. The social, cultural, and economic rights would include the right to participate in culture, the right to work, the right to an adequate standard of living, and the right to education. Human rights were legally recognized for the first time in 1948 by the UN in its Universal Declaration of Human Rights, which emphatically stated that every human being has an inherent right to life and no derogation by any state party is permissible even during the period of emergency. This declaration inspired a range of international and regional human rights treaties which continue to be developed even to this day. Many countries, including India, have also made rights a part of their own laws. Human rights are essentially centered around the relationship between a state and its citizens. Governments are required to protect people's rights. Media coverage about human rights abuse is essentially in the context of government not protecting rights of its citizens. Others, such as businesses and local governments, are also responsible for respecting people's rights. The most important contribution the present human rights law offer with respect to sustainable development and environmental protection is empowering of individuals and groups affected by environmental problems, and for whom the opportunity to be able to participate in decision making is the most valuable and direct course of action for influencing the balance of environmental, social, and economic interests. Now, the question is the environment a constituent of human rights? Environmental impacts on life, health, private life, and property of individual humans has a bearing on human rights. Including environment as a constituent of human rights can help to guarantee higher standards of environmental quality based on the obligation of governments to take measures to control pollution affecting health and private life. Furthermore, rule of law is promoted in the context of environment as states become directly accountable for the failure to regulate and control environmental nuisances, including those caused by corporations. Also for facilitating access to justice and enforcing environmental laws and judicial decisions. Finally, the expansion of social and economic rights to include elements of the public interest in environmental protection has infused new energy to the idea that there should be, in some form, a right to a healthy environment. The debate on environmental dimension of human rights has been largely put forward by environmentalists or generalist international lawyers, and remarkably, environmental dimensions have not been or have only rarely been discussed in general academic treatment of human rights laws. But the growing load of environmental cases of human rights and the treaty bodies demonstrates the importance of environmental issues in mainstream human rights laws. The presence of environmental dimensions in essentially human rights treaties such as the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the European Convention on Human Rights, the American Convention on Human Rights, and the African Convention on Human Rights indicates a greening of existing human rights law and not the addition of new rights to existing treaties. The main focus of the case law has therefore been on the rights to life, private life, health, water, and property. Environmental provisions in some of the main human rights treaties are usually phrased in relatively narrow terms focused on human health. UN institutions recognize that civil, political, economic, and social rights have environmental implications that could help to guarantee some of the indispensable attributes of a decent environment. A report from the Office of the High Commissioner on Human Rights in 2009 emphatically recognized that while the Universal Human Rights Treaties do not refer to a specific right to a safe and healthy environment, the human rights treaty bodies all recognize the intrinsic link between the environment and the realization of a range of human rights such as the right to life, the right to health, the right to food, to water, and to housing. The report from the Office of the High Commissioner on Human Rights identified three theoretical approaches in the relationship between human rights and environment. Number one, environment is a precondition to the enjoyment of human rights. Number two, human rights are the tools to address environmental issues both procedurally and substantially. And number three, human rights and environment are integrated through the concept of sustainable development. The United Nations Human Rights Commission, or the UNHCR, also recognizes in its Resolution 2005/60 the link between human rights, environmental protection, and sustainable development. The resolution encourages all efforts towards the implementation of the principles of the Rio Declaration on Environment and Development. Principle 10 of the Rio Declaration is particularly referenced in order to achieve effective access to judicial and administrative proceedings, including redress and remedy. Principle 10, like the AARHUS Convention of 1998, acknowledges the importance of public participation in environmental decision-making, and its implementation is most significant. Principle 1 of the Stockholm Declaration of 1972 on the human environment emphasizes that clean environment, both natural and man-made, are essential for the well-being of humankind and for the enjoyment of basic human rights, including the right to life itself. The AARHUS Convention includes Principle 1 in its preamble and asserts that every person has the right to live in an environment adequate to his or her health and well-being, and the duty, both individually and in association with others, to protect and improve the environment for the benefit of present and future generations. The AARHUS Convention focuses on procedural rights that are limited to public participation in environmental decision-making and access to justice and information. The Convention draws from Principle 10 of the 1992 Rio Declaration on Environment and Development, which explicitly advocates the same category of procedural rights. Public participation is a key constituent in sustainable development, and the incorporation of procedural rights advocated by the AARHUS Convention into general human rights law can significantly advance this objective. The AARHUS Convention is essentially for procedural rights, but it has three important characteristics which in essence qualify it as a human rights treaty. Number one, it provides for access to justice and procedural elements that serve to protect the right to life, health, and family life. Number two, rights are conferred directly on the individual and not simply on the states. The Convention allows members of the public and NGOs to bring complaints before a non-compliance committee whose members may be nominated by the NGOs and are independent of the parties. Number three, access to information, public participation in environmental decision-making, and access to justice. These characteristics bring the AARHUS Convention closer to human rights treaty monitoring agencies rather than to the non-compliance procedures typically found in multilateral environmental agreements. The AARHUS Convention is also important because, contrary to human rights treaties, it provides for public interest activism by NGOs made unique by the grant of locus standi to claimants with a sufficient interest to engage in public interest litigation, even when their own rights or rights of the victims of a violation are not an issue. Here it should be noted that while the AARHUS Convention came into existence only in 1998, Indian jurisprudence has provided for public interest litigations since the 1970s. In fact, the Constitution under Article 39A has made a provision for public interest litigation in India. Article 39A states, "The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities." Article 39A is part of the directive principles of the Constitution of India and was inserted by the 42nd Amendment of the Constitution. The article was inserted to aid state organs, more particularly the judiciary, to protect and promote social justice through the instrumentality of law. I will just list out some of the distinctive features of a public interest litigation. Under the public interest litigation, the scope of the law is not limited by a specific historical event, such as a breach of a contract or a personal injury, but is consciously shaped by the court and the parties. The party structure is not limited to individual adversaries, but is sprawling and amorphous. The fact that the inquiry is not a simple investigation of past historical events, but rather resembles the kind of inquiry into current problems undertaken by legislative bodies. Relief is not limited to compensation for a past wrong, but is often prospective, flexible, and remedial, having broad impact on many persons not party to the lawsuit. The relief is often negotiated by the parties rather than imposed by the court. The judgment does not end the court's involvement, but requires a continuing administrative judicial role. The judge is not passive, but plays an active role in organizing and shaping the litigation. The subject matter of the litigation is not a private dispute, but rather a grievance about public policy. I would like to now take up how environment has been incorporated among the body of rights under the Constitution of India. We will just go back to what the Universal Declaration of Human Rights of 1948 and other human rights treaties like the International Covenant on Civil and Political Rights of 1966 state. Every human being has inherent right to life, and no derogation by any state party is permissible even during the period of emergency. This gets reflected under Article 21 of our Constitution, which is the fundamental right to life. Article 21 states, "No person shall be deprived of his life or personal liberty except according to procedure established by law." Whether the provisions of the Universal Declaration on Human Rights and the International Covenant on Civil and Political Rights are a part of our Constitution, or rather incorporated or reflected in our Constitution, came to question at the time of the emergency when the emergency was imposed on 25th of June 1975. In a case between ADM Jabalpur versus Shukla, the question was asked, are the Universal Declaration of Human Rights of 1948 and the International Covenant on Human Rights of 1966 part of the Indian law? The Supreme Court responded by saying no. These submissions appear to me to amount to nothing more than appeals to weave certain ethical rules into the fabric of our Constitution, which is the paramount law of the country and provides the final test of validity and enforceability of rules and rights through the courts. To advance such arguments is to forget that our Constitution itself embodies these rules and rights. However, in subsequent cases, Supreme Court indeed began to incorporate the human rights as envisaged by the Universal Declaration of Human Rights. And after the lifting of the emergency and encouraged by an atmosphere of freedom and articulation, the Supreme Court entered one of its most creative periods. Specifically, the court fortified and expanded the fundamental rights enshrined in Part 2 of the Constitution, and in the process, the boundaries of the fundamental right to life and personal liberty guaranteed under Article 21 were expanded to include environmental protection. The Supreme Court strengthened Article 21 in two ways. Number one, it required that laws affecting personal liberties should also pass the tests of Article 14 and Article 19 of the Constitution, and thereby ensuring that the procedure depriving a person of his or her personal liberty are just and fair. Number two, the court recognized several unarticulated liberties that were implied by Article 21. It is by this second approach that the Supreme Court interpreted the right to life and personal liberty to include the right to a clean, wholesome environment. In the case involving Kshetriya Mukti Sangharsh Samiti versus the state of UP of 1990, the Supreme Court observed that every citizen has a fundamental right to have the enjoyment of quality of life and living as contemplated by Article 21 of the Constitution. Anything which endangers or impairs by conduct of anybody, either in violation or derogation of laws, that quality of life or living is entitled to be taken recourse of under Article 32 of the Constitution. Article 32 empowers the citizens to file a writ directly in the Supreme Court in case of violation of any fundamental right by the state. In Subhash Kumar versus State of Bihar in 1991, the Supreme Court observed that the right to life under Article 21 of the Constitution has been held to include the right of enjoyment of a pollution-free air and water. Likewise, in the Indian Council of Enviro-Legal Action versus Union of India, the Supreme Court has implemented the right to wholesome environment as a part of right to life enshrined in Article 21. Coming to how the Supreme Court reads Article 14 and 19 into Article 21. So let's start with Article 14, which is the fundamental right to equality. Article 14 states, "The state shall not deny to any person equality before the law or the equal protection of laws within the territory of India." Article 14 enshrines the right to equality before the law and protects a person against arbitrary or unreasonable state actions. Article 14 prohibits arbitrariness because every arbitrary action violates the principle of equality enshrined in it. This is what happened in rural litigation and entitlement Kendra versus state of UP, where uncontrolled mining licenses were being given to anyone who approached to acquire a license for mining, irrespective of whether he or she had any experience in mining or not. The same was the case in Kinkri Devi versus state of Himachal Pradesh, and in both these cases the Supreme Court incorporated Article 14 in saying where there is arbitrariness, there is bound to be a violation of equality. A common defense which any environmental violators would take would be by resorting to Article 19, which is the fundamental right to profession, trade or business. Under Article 19, 1, all citizens have the right to practice any profession or to carry on any occupation, trade or business. However, there is a proviso under Article 19(1)(6) which says, "This shall not prevent the state from making any law imposing in the interest of general public a reasonable restriction on the exercise of the right conferred by the said subclause," that is, the right to any profession. In cases involving the closure of polluting industries, the courts face the task of balancing the environmental imperative with the fundamental right to carry on any occupation, trade, or business guaranteed under Article 19(1)(g). No one has the right to carry on business in the manner by which the business activity becomes a health hazard to the entire society. In Abhilash Textiles versus Rajkot Municipal Corporation, I'll briefly list out the facts of this case. This industry was carrying on a dying business close to a residential area, and all the effluents from this industry were being discarded into the drains of the residential area nearby. And this was causing a lot of problem for the people who were living there. When these people approached the local municipal corporation for remedy, the local municipal corporation asked the said industry to shut down their industry or install effluent treatment plants. The company responded by saying that they do not have the necessary finances to install an effluent treatment plant, and because by their industrial activity is providing employment to a range of people, so therefore Article 19 gets violated if the company is shut down. The commissioner nevertheless issued the order for closure. Agreed by this decision, the company approached the court, and the court observed, if the petitioners wish to carry on the business, they may have to incur expenditure, and they must provide for the purification plant before discharging the effluent water on the public road or the drainage system. The petitioners cannot be allowed to reap profit at the cost of public health. This is the mandate of law. The Constitution also bestows duties on the state as well as the citizen. Under the 42nd Amendment to the Constitution of India, Articles 48A and 51AG were introduced. Both of these articles form a part of the directive principles of state policy and are called the fundamental duties. Article 48A states, the state shall endeavor to protect and improve the environment and safeguard the forests and wildlife of the country. Article 51AG states, it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. In D.D. Vyas versus Ghaziabad Development Authority and in Obaya Pujari versus Karnataka State Pollution Control Board, the court observed that when the court is called upon to give effect to the directive principles and the fundamental duties, the court is not to shrug its shoulders and say that priorities are a matter of policy and so it is a matter for the policy-making authority. The least that the court may do is to examine whether appropriate considerations are borne in mind and irrelevancies excluded. In appropriate cases, the court may go further, but how much further depends upon the circumstances of the court. But how much further depends upon the circumstances of the case. The court may also give the necessary directions. In rural litigation and entitlement Kendra versus the state of UP, the court observed, preservation of the environment and keeping ecological balance unaffected is a task which not only the government but also every citizen must undertake. It is a social obligation, and let every Indian citizen be reminded that it is his fundamental duty as enshrined in Article 51AG of the Constitution. Article 48A treats the state as a deemed polluter if it fails to abide by the mandate of protection and improvement of the environment. Article 51AG gives effect to the well-known principle of international environmental jurisprudence, namely polluter pays principle, by requiring the polluter to bear the costs of pollution.